Still talking elections in Nigeria, the Independent National Electoral Commission has excluded the name of the candidate of the All Progressives Congress, APC, Timipre Sylva, from the final list of candidates ahead of the November 11 governorship election in Bayelsa State. The amended list, which was uploaded on the Commission's website on Tuesday, was signed by the Secretary to the Commission, Rose Oriaro Anthony. According to her, the action of the Commission was in obedience to the court orders on the lists served on the Commission. Recalling that the Commission published the final list of the candidates for the 2023 Bayelsa State governorship election on June 9 in accordance with provisions of the Section 23 of the Electoral Act 2022 and the timetable of schedule of activities for the election. She said that after the publication, INEC was served with an order of court in respect of the nomination of candidate for the APC for that election. On October 10, the Federal High Court in Abuja disqualified Timipre Sylva from participating in the state governorship election. Well, joining us to discuss this is immediate past Commissioner of Information in Edo State, Andrew Emwanta. Andrew, thank you very much for your time. Glad to have you. Can you explain the legal basis for exclusion of Timipre Sylva from the final list of candidates?
Yeah, thank you. It's a pleasure to be here this evening, and good evening to our viewers at home. The position has always been that once there's a court judgment, INEC is bound to obey that court order or judgment, as it were. Remember, just as we noted, there was a decision of the Federal High Court that because the candidate of my party, the APC, had taken oath of office twice, and the fact that he had occupied the office of governor previously for 5 years, that it would be impossible for him to do one more term, which will exceed the maximum constitutional limit of 8 years. Of course, that is the law, and I think INEC was not wrong in following that court order. But as a constitutional lawyer, I have issues with the person who brought that action. Namely, the Electoral Act and the Constitution contemplates election, or rather pre-election actions, as actions that only an aspirant can file. And even if you look at the community reading of Section 285, sub 14 of our own 1999 Nigerian Constitution, which is the ground norm of Nigeria, it clearly says that pre-election matters are actions that can be brought by, first, an aspirant of a party, then second, by a political party. The person who brought this action is a member of the APC, and not an aspirant or a political party. So he lacks the local standard. Though this matter is before the Court of Appeal, so we expect the Court of Appeal to give judicial interpretation of the clear provisions of both Section 285, sub 14 of the 1999 Constitution and the relevant provisions of the Electoral Act that says that it is only an aspirant that can bring a pre-election action of this manner. But that is not to say that constitutional lawyers will not argue that because it is a matter of constitutional interpretation, any citizen that has interest can bring this action. And secondly, from the fact the action was not brought within 14 days, because all pre-election matters must be brought before the court, either the court of first instance, which of course is the Federal High Court. Because it is a pre-election matter, it was not brought within 14 days. So the APC lawyers, I believe, are already putting up arguments before the Court of Appeal, but this is just a temporary setback for the candidate of the APC in Bayelsa. If the Court of Appeal upturns that judgment, I know INEC will do the needful. But if that is not the case, which I pray should not be, it therefore means that APC will be without candidate in that election. But because the matter is sub judice, I think it is better for us to allow the Court of Appeal to decide. And I think it's a matter that the Court of Appeal must decide timeously, because Bayelsans are still asking this question. Does APC have a candidate? Because in the eye of the law, because of that judgment, APC does not have a candidate.
All right, Andrew, very interesting point you've raised. Just quickly to follow up on what you just said, the technicalities, as we've gotten used to that word, of if the complainant is a party to any of the the primaries, or a candidate of the or an aspirant in the party, or if he's just a regular member of the party. Also looking at the 14 days, Do you think the courts may want to look at the law, and if in the eyes of the law, or to look at this case on merit and on account of justice, let me call it that, since you said, you know, he may have, he may be flouting one or two constitutional provisions?
Yeah, you know, the drafters of our constitution did not create room for floodgates, in the sense that for you to challenge an election at the level of primaries, which is not as we know it to be, which for us as constitutional lawyers, anything before the election is a pre-election matter. And the drafters of our constitution has made it impossible for anybody to just come up with an action. And you know, there's no proper way to do the wrong thing. If somebody lacks locus standi, I don't think any court of competent jurisdiction will clothe him with locus standi. And what is the meaning of locus standi? The right to bring an action. Assuming but not conceding that this action was brought by a political party, of course that political party has locus standi to ask the court to interpret. If the candidate of the APC, Timipre Sylva, at the time of the primaries was qualified, if he was not caught up by the constitutional 8-year limit provision, that a candidate for an election, assuming he was governor before, must not have served more than 4 years, which we know is the case. So my feeling is that the court will look at two things. Namely, was this action brought within 14 days? And secondly, was the person who brought this action clothed with locus standi? Did he have the right to bring this action?
It could be argued that because he's a member of the party,
an aspirant.
Yeah, it could be argued that because he's a member of the party, he may have some grievances and reason to want.
Well, the thing is, if he had any grievance at the level of screening, he would have brought up these issues. He would have even come through an aspirant who participated in the primaries. But as we know it, it's only an aspirant that can bring a pre-election matter, or as it were, a political party within the meaning of Section 285, sub 14 of our 1999 Constitution.
Okay.
So for me, I think it may be a temporary setback because the Court of Appeal definitely will give its judgment before the election. So I think it's better wait for the Court of Appeal, because once the Court of Appeal gives its decision, the space, because when you look at the space of the APC, what you have there is court order. Until the Court of Appeal rules, it will remain so. So if the Court of Appeal now says the decision of the trial court was wrong, first, because of the issue of locus standi. Second, because the action was not brought within 14 days. You know, there's what we call the limitation period. All election petition and all pre-election matters must be brought within 14 days.
Okay.
This action was not brought within 14 days, and it was not brought by a person who has locus standi.
Thank you, Andrew. Andrew, how does this situation impact the overall integrity of the election process? Let's recall that yesterday.
Democracy, because INEC.
Yeah, sorry to just add to that question, Andrew. Yesterday, if you remember, the chairman of INEC had complained, lamented the cost of printing ballot papers and other sensitive materials again, you know, because of court orders. It's costing INEC. So how does this affect the whole process, in your opinion?
If you ask me, I think it will not be wrong if INEC decides not to, publish the name of the candidate because of the court order. But at the same time, what if the court now holds otherwise? Will you not deprive the person? Will you not say because the candidate of a particular political party, there's a court order, so you will not preclude that political party from participating? So that is why I think the Court of Appeal can save the situation by giving its decision timeously, taking the cue from the Supreme Court. Remember, it was on Monday that parties in the presidential appeal adopted their brief of arguments, and the judgment is coming tomorrow. Within 4 days, the Supreme Court is about to give a landmark decision. This is a landmark case, and I expect the Court of Appeal within the next 7 days to give its decision. It's a purely legal issue that borders on the Constitution or touches on the Constitution. It is not really factual per se. So we expect the Court of Appeal to rise up to the occasion in giving its verdict timeously, so that INEC would not end up printing ballot papers when at the 11th hour the court now gives a decision that would have affected the process. So I expect the Court of Appeal to rise up to the occasion and give its decision timeously. And allow Bayelsans to have a clear head on who they should vote for. Because the APC as a political party, it will do a whole lot of damage to the APC if the decision of the Court of Appeal comes at the 11th hour.
Thank you very
time is
much.
of the essence.
Thank you very much. Andrew Emwanta, a pleasure
to be here.
to have you on the program tonight, immediate past Commissioner of Information in
Thank you for
Edo
having me.
State, Nigeria South. Thank you very much for your time.